Thankfully, the likelihood of having to use deadly force to defend yourself is extremely small, but that doesn't mean that you shouldn't give very serious thought to what you would do if you find yourself in such a situation. Obviously, if you've had to use your firearm in self-defense, you're going to have to call the authorities, both to report what has happened and to summon help for the person who attacked you. Just as sure as that the police are going to want you to tell them what happened. While most law-abiding citizens want to do exactly that, the problem is that in the aftermath of such a traumatic situation, you're physically unable to give an accurate and complete account of what transpired. Our bodies undergo a dramatic physiological change when we are thrust into extremely stressful circumstances. This change manifests itself in several ways, such as tunnel vision, auditory exclusion, distortion of time and space, and decreased awareness of pain. It also causes cognitive and memory impairment. These impairments are only made worse when you try to recall details of what just happened while you are still feeling the effects of these physiological changes. As a result, people who are asked to describe a traumatic incident in the immediate aftermath are largely unable to do so. This can become a legal problem if you give one account of what happened right after the incident and a differing account of what transpired once you have the benefit of your body returning to its normal state. Police, prosecutors, judges, and juries can misinterpret this inconsistency as deceptiveness, even though that's absolutely not what it is. For this reason, lawyers advise their clients to refrain from making detailed statements right away. Incidentally, when police officers themselves must use their firearms in the line of duty, they'll often delay giving a statement to investigators for as long as possible, and sometimes for as much as 48 hours. The reason for this is exactly the same as why you shouldn't give a statement to the police. You simply can't recall all of the critical information in the immediate aftermath of a defensive firearm use. If a trained police officer is unable to do so, how do you think that an ordinary citizen who is not regularly put in harm's way can? The answer is simple: you can't. As explained in the book, when you contact the police to report a defensive firearms use and request emergency medical assistance for your attacker, you should tell them only 4 things. I was attacked by that person. There is the evidence. That person was a witness, and I've spoken with my attorney, and I'm going to wait until he or she arrives to give a statement and sign a complaint. If you follow this protocol, you will minimize the risk of an honestly given but incomplete statement later being used against you in court.